So thank you all so much for joining us today. We really appreciate your time. Everything's busy, everything's a lot. We know this. So hopefully you've managed to grab a cuppa or some lunch, or can take a little bit of a break and hang out with us for the next hour at least, and shut out those other distractions. So today we've gathered to talk about Australia's new Online Safety Act, which did pass through both houses of our government and has become law and will be the law of the land as of January 2022. So given that it is new legislation that covers our digital lives, our working lives, our personal lives, and for those of us who oversee digital spaces, be that as online community managers, some as social media managers, some as online moderators, or combinations of those things, it does impact our environments and our work. So we thought it was important to bring everybody together and give you a bit of a briefing, particularly if you're unfamiliar with the Act. Today should be really useful to load you up on some high-level understanding of what it's all about, what it contains. We're going to examine how it impacts what we do as well, and then we're gonna talk through some questions as well that we have. So we're going to look at, in particular, what the Act is, exactly what it addresses, the impacts, as I said, for online community managers and hosts. We're going to offer some suggested tips to help you prepare and comply that are more relevant to anyone out there who is running an owned community versus running a community on social media, but broadly relevant for everybody. Also very relevant for anyone who is building products that host online communities. So we know there's quite a lot of online communities in Australia that are hosted in private apps that are built proprietarily by those organisations. They do so actually usually so they can control the safety of those environments more. So they will have some new considerations to think about. And then, as I said, we're gonna open up for any questions and have a bit of a chat. We will do our best to answer any questions that you have today. We've spent a bit of time with this Act. We did pull together a submission for it during the submission stage. And those questions that we can't answer, and there may well be some, we will be forwarding along to the team at the Safety Commissioner, who have kindly said they will help us out with responses. So we'll come back to you on those. Before I go on, it is important for me to say that I'm neither a lawyer nor a legislator, and nothing that we talk about today should obviously be taken as legal advice. And you should always seek dedicated professional legal counsel for any of those sort of matters. This is just intended as a general overview through the specific lens of online communities and social media in Australia. Okay, so what's the Act all about? Well, it's pretty much, as it says on the tin. The stated objectives of this new Act are to improve online safety for all Australians and to help promote online safety for all Australians. And there's a few different components that help it achieve that. There is a very similar bill that is actually currently before the UK Parliament right now as well. It is a little different. There are some critical differences, but it's very similar in its broad intentions and in the way that it tries to enshrine sort of basic standards around safety for the life of its citizens online. Another really important intent of this Act is to streamline the previous legislation that existed in Australia. So, as many of you would know, or may have even been involved in, there's been a number of different pieces of legislation over the years, sometimes dedicated legislation, sometimes incorporated as components of other legislation or other regulatory bits and pieces that impact our online lives. Now, this doesn't consolidate every single one of those, but it does do a pretty admirable job of bringing a lot of them under the same umbrella, absorbing a few and trying to create harmony between all of that. So it all is a little more cohesive, makes a little more sense, and there's quite a lot of consistency across the board. So we think that's a really good move, and it is something that as ACM we did applaud in our submission. The Act also gives the eSafety Commissioner, which is obviously an increasingly critical regulator in Australia, heightened powers to enforce standards that the Act lays out and any breaches of those standards. And we'll look at what that is as we go along today. So one of the most important components of this new Act is the introduction of basic online safety expectations, otherwise known as BOSE, and we're going to look at those in particular shortly. It also goes through and offers some additional protections against specific online harms, and they are cyberbullying against children, which was covered under a different piece of legislation previously. It introduces world first rules and legislation around cyber abuse against Australian adults. It covers the non-consensual sharing of intimate images, sometimes known as revenge porn. It incorporates rules around exposing inappropriate audiences such as children to Class 1 material, which is material that is restricted classification in Australian regulatory environments, and Class 2 material, which is things that are rated X or rated R, so things like graphic pornography. It also covers material that is depicting abhorrent violent conduct, so something like a terrorist act, rape, attempted murder, these sort of things. So for example, the live streaming of the horrific Christchurch attack a couple of years ago, that type of content would be considered abhorrent violent conduct. So that is also brought under this new act. In terms of the legislation that it absorbs and consolidates, it repeals the 2015 Enhancing Online Safety Act. So that is no longer a thing once this comes into effect. It replaces the existing cyberbullying scheme that the government had that was focused on children. So it basically takes all of that across and extends and enhances it somewhat. It offers some amendments to the Broadcasting Services Act of 1992, the Criminal Code of 1995, and the Sharing of Abhorrent Violent Material Act of 2019, which was created in response to the Christchurch attacks. Importantly, this act is designed to work concurrently with our criminal code, so it doesn't replace any of those things. And somebody who is in breach of this act for a particular issue, and again we'll look at what those are, could also find themselves charged with a crime if the parties involved would like to raise charges and it's deemed that a criminal offence has occurred. So for example, using a carriage service to menace, harass or cause offence is probably the most common criminal code that applies here. One other thing that the Act does, notably, is it extends the jail term for that sentence. So at the moment, the maximum jail term for that section is 3 years. This Act actually extends that to 5 years. So if somebody is charged under that as part of running afoul of all of these codes and acts, then they could potentially face up to 5 years in jail time. So that's where you see those headlines about, trolls could potentially face jail time. They could potentially. So who does this act apply to? Well, that's another new feature of this act, really. A lot of that previous legislation applied to either broadcast material, and how exactly that applied to the internet has always been a little fuzzy in practice, or things applied directly to social media services, such as your Facebooks, Twitters, and so on. This act actually encompasses a really wide range of digital services and end users as well. So it does take into, under its umbrella, social media services, and that's defined in the Act as, these definitions are really important, a service whose sole or primary purpose is online social interaction between end users, something that allows end users to link or interact with either some or all of those other end users, and something that allows those end users to post material on the service. So if you have an owned forum, you've got forum software and you're running a customer community for your business, that is a social media service, regardless of any other business or transactional purposes of that. For the purpose of this Act, that software, that service you're providing is about connecting those individuals, and therefore it would fall under the definition of a social media service. It also applies to designated internet services. That is things like internet service providers, but also things like search engines, which carry material and connect it to people that are accessing the internet. It also extends to relevant electronic services, which the Act defines as email, instant messaging services, SMS and MMS, so it's quite expansive. And app distribution services, so your app stores, your Apple stores, your Google Play stores, if they are distributing content that is known to be in breach of some of these standards or be containing material that is covered by this Act, then they may receive a request to take that link to that app down and to no longer distribute that app. It also applies to end users of these services. So as an end user, I could receive reports against me and take down notices under this Act as well. So, and we'll look at what all of that means shortly. here is a really high-level summary from Gilbert and Tobin, a law firm. I thought they did a nice job, so I wasn't going to replicate it, of the various components of this Act and which of these groups, which of these stakeholders they actually apply to. So not everything applies to everyone. So removal notices for things like cyberbullying abuse material, non-consensual sharing of intimate images, that applies to social media services, relevant electronic service providers, designated internet service providers, hosting service providers, and the end users who may post that material. So quite broad there. Removal notices for class 1 and 2 material. Remember, that's restricted classification and X and R rated material. Again, pretty consistent. Everybody except the end user. Blocking notices for abhorrent violent material, that applies to internet service providers. App removal notices obviously only applies to the app stores. Link deletion notices, that would apply to search engines to take certain links offline or restrict access. And the basic online safety expectations, which we'll have a bit of time looking at, they apply to social media services, and this is important for us, relevant electronic service providers, internet service providers, and well, it doesn't say so, they sort of broadly apply to end users in that they have to adhere to those if they're going to not run afoul of this Act very broadly. So that's kind of a nice encapsulated summary of all of that for you. You will receive copies of all of these slides, by the way, so take all the notes you wish, of course, but please don't stress about having to capture everything. We'll make that available to you. So, all about the boast. Let's talk about basic online safety expectations. This is, I think, one of the most important steps of this legislation, is to try and do the very difficult task of codifying what are basic online safety expectations. Obviously, that can be a challenging thing to draw consensus around, and to stipulate that they be enforced by different folk. One of the big challenges that we've all had working in this space, seeing the harms that can play out on either side of the fence, as users, as community managers, working for organisations that build software sometimes as well. Is there is not agreement on what those are necessarily, and they're too often an afterthought, I think. So for a lot of companies, particularly new startups and companies that are just excited about building services and connecting them to people and getting them to use them, they often think safety can come later, or can sort of come. Yeah, we'll cross that bridge when we come to it. And many of us in the room now know that that's easier said than done, and actually there's a considerable amount of harm that can be wrought if you allow that to happen. So it is really important to do these things early on. There are still some concerns. This is not expansively applied to everyone, and I know Jen Beck and I, for example, have been advocating that it should be applied to startups in this space as well. Currently, it's not necessarily. There's some exemptions for those that might not have the resources to do this, and I don't know that that's sending the right message around consistency, in my opinion, but that is what it is, and at least this is a really fantastic start to get some things on the board, I think. So they do apply to social media services, they apply to those relevant electronic services and designated internet services, and it really expands on the initial Enhancing Online Safety for Children Act of 2015, which you recall has now been replaced. But that only applied to social media services. Interestingly, these standards are ministerially determined. So that means they will be iterative, and they could change depending on political preferences, and in theory be guided at all times by the common standards of the wider community and the day. So we've seen no evidence that they will be particularly reflexive in that way. I'm sure that we're going to give them a chance to work. But theoretically, they are led by and determined by the minister for this space. So what do they actually say, these standards? So on the surface, they are, I think, very reasonable. I think most people would be hard pressed to agree, but for some, it does mean some extra work and some new things to do. So remembering that this applies to all social media services. So if you are a online community platform vendor, this will apply to you if you're operating in Australia. You need to take all reasonable steps to ensure people can use the service safely. You need to minimise the extent to which any harmful content, say that is for some reason available on your service, is accessible. So you need to minimise that. Take all reasonable steps to prevent children accessing any kind of harmful content, in particular class 2 material. So there's that graphic sexual material. Ensure, this one's an important one and you'll recognise it, that there are clear and readily identifiable mechanisms for end users to report and make complaints about harmful material. Now that is something I know that not all community platforms have paid attention to in the past, and that is something that these expectations now they'll lay out as required. So great community platforms are already doing this well, so for them there's very little that they'll need to change. But if your community platform does not have a reporting mechanism, either an individual report abuse flag, something like that, or at the very least, a clear way to sound the alarm and contact a moderator, contact a community manager, then you would not be compliant with these expectations. The other expectations are that those organisations respond to all notices from the eSafety Commissioner, things like takedown notices or notices of removal. And the time frame on that has been increased with this Act. So historically, where there was one, it was typically 48 hours. Now it has been increased to 24 hours. They must also respond to any requests from the Commissioner for details about the way they're complying. So if you think about the transparency reports being released by organisations like Twitter, Reddit, that talk about, we've received this many requests for information, we had this many moderation issues, we took down this much harmful content. Organisations need to be ready to, they don't necessarily need to produce a report, but the larger ones may choose to do it, may actually organise it that way. They need to be ready to answer those questions. So if the Commissioner says, we need to know how many complaints have been filed with you, or how many reports of abuse this last month, how long did it take you to comply with those, and what did you do to respond to those? How did you change the way you did things, or how did you, did you remove the content, did you ban a user, what was your actual moderation decision-making process? So they have the right to ask for that information about any particular time frame, and they will give you a reasonable time to gather that information, but it is expected that you be recording it in some way and that you have access to it and be prepared to gather it if asked. So one of those important areas covered by the Act is obviously cyberbullying for kids. So I wanted to just briefly look at this. Now, most online communities in Australia do not specifically serve children, although we do know that many children do inhabit online communities, whether they're specifically designated for them or not. So I will spend a bit of time on this. So cyberbullying under the Act covers content that is posted by anybody targeting a child. So it may be another child or it may be an adult. There are some exemptions in the Act carved out for certain authority figures and certain particular relationships with children where a child might interpret something as being particularly harsh, but might be actually fair and equitable in the context of that authoritative relationship. And obviously that doesn't stop anybody from reporting the information, but it might be deemed that actually it's excluded because of that criteria. So there's some detail to pay attention to there, but broadly, all of the Act does use the ordinary reasonable person sort of principle that a lot of our legal system does, which is that an ordinary reasonable person would conclude by looking at that material that it was intended to have the effect of one of these things, either seriously threatening, intimidating, harassing, or humiliating that child. It could be one or any combination of those. So if the eSafety Commissioner receives a report of this, people can report this directly to the platform, to the Commissioner. They can order both the platform it is hosted on, so the social media service, be that a public platform like a Facebook or your online community if you host it directly, and the end users, if they wish, to take down that content, in this case within 48 hours. They may also require specific conditions, such as you need to apologise to those individuals. Oh, that's a great question, Amanda. Yeah, so technically it is those defined as minors under Australian law. So I'll just double check for you. Where are we? I think it's under 18 actually, but let me check. I'll confirm in 1 minute and get back to you. It's a great question. So the adult scheme. Now it really is significant. It is a world first. So Australia is, whether you like or don't like, oh, thanks, Claire. That's an excellent question. It is an excellent noteworthy scheme, whether you agree with its intention or not, in that it really is a world first. So this is extending similar principles and mechanisms to content posted by adults targeting fellow adults. So this is, of course, most of the abuse that we see online, most of the abuse that many of you have seen and see play out in your communities, especially on public social media platforms, is now subject to this Act. So again, the material needs to be considered by an ordinary reasonable person as either menacing, harassing or offensive. Now, they do take the time to qualify what offensive means, because obviously that is highly interpretive. They have a few different points in the Act around broad community standards of decency that sort of help you contextualise. And I think it is actually fairly clear. Certainly there's room for legal argument in all of these things, but it's not left unqualified. In addition, and this is an important piece, they add that an ordinary, reasonable person needs to conclude that the material was intended to cause serious harm to the target. Serious harm is the exact phrase. I will explain what that means. They have also offered a definition of that, which is very helpful, because otherwise it is highly interpretive. And that harm can happen, importantly, by either accessing the content directly. So somebody sends me, tags me and messages me publicly in a forum that others can see and interact with, or indirectly. So I might be being discussed in an online community without me being there. Somebody might say, hey, have you seen those folks are talking about you? Have you seen the content that's shared? Or they share it to me. They share screenshots or links or things like that. So it doesn't need to explicitly pull me into the conversation or the content, but it does need to be accessed by me at some point, including distribution by others. So serious harm, this was something ACM actually, among many other submission folk, requested that the Act define, because it was not explicitly spelled out. So the Act defines serious harm as either serious physical harm or, and it's very important and good that this is included, a serious harm to a person's mental health, whether temporary or permanent. They further qualify, this is the exact language of the Act here. Serious harm to a person's mental health includes serious psychological harm and serious distress, but they say does not include ordinary emotional reactions such as distress, grief, fear, or anger. Now, again, there is still room for, there's squiggly lines here, there's room for interpretation, and I can definitely see there will be issues and incidences of abuse that some may argue do not, the Commissioner may find do not meet this standard, even though the target of that abuse does feel it certainly does in earnest. So it's imperfect for sure, but I think to me at least, I think it's it's a good step in the right direction, and certainly better than the absence of it. So it needs to be tested. So we need to give it a chance to play out and see. The E-Safety Commissioner receives, I think it was upward of 1,000 reports of adult abuse, but previously they've not had any official mechanisms to actually deal with it. They can't investigate it under the law. Now they can. So, all they could really do was offer some general assistance, connect people with various resources, encourage them to report it to platforms. But as many of us know, that doesn't always solve the problem, and not always in a timely fashion. So how does the reporting side of things work? Well, the exact reporting mechanism hasn't been laid out yet. Presumably it's going to be an online form of some kind. It's yet to be announced precisely. But if the Commissioner receives a report of cyber abuse that meets that threshold we just discussed, they can issue removal notices to either the service it sits on or the end user or both, requiring takedown within 24 hours. If that organisation or that individual is non-compliant, there are fines, civil fines, penalties up to $111,000 for the individual, so that's your troll fine, and potentially up to $555,000 for organisations. For a notice to be issued, it has to meet some criteria. So for the E-Safety Commission to actually issue that, it has to tick these boxes. It has to satisfy those conditions we just discussed. It has to be accessible to Australian end users, and that really applies to everything in the Act as well. It has to have been subject to a complaint to the platform. So if you are the target of that abuse, you need to report it to the platform before you can go and report it to the e-safety commissioner. And then it has to have been failed to be removed by the online service provider within a reasonable period of time. So given that there is not a stipulated takedown requirement for that component of this process. So that's a little unclear, but I imagine it might be reasonable to say, I reported it, it's 24 hours later, given that that's actually the time frame the Act lays out, perhaps you can then go and actually report to the Commissioner. We'll see how that plays out. That's one of the questions I'm going to ask. And then you have to obviously go and make your complaint to the Commissioner. So if you follow those steps in that process, satisfies the conditions, it's accessible to Australian end users, you've complained to the platform or the service, nothing's been done, and then you go and complain to the Commissioner, they assess it, and then they can go and issue that removal notice that requires that takedown, and for non-compliance, they will issue a fine. Again, that does not preclude individuals from, depending on the nature of the content, from bringing criminal charges under that earlier section of the Criminal Code. We discussed the intent to menace and harass. So that's probably the most noteworthy component of this new scheme, and I'll talk about how we think that's going to actually, in reality, affect our communities and community management shortly. The other component I mentioned is the blocking of content. So this is really, designed to prevent that rapid proliferation, that rapid spread of really harmful content that is often, unfortunately, these days live streamed, such as the Christchurch attack. So the Act now gives the Commissioner new power to either require or request ISPs to remove and block access to any material that depicts, incites, or instructs abhorrent violent content. That's the language of the Act. The material must be likely to cause significant harm or harms to the Australian community or large contingents of the Australian community, and the Commissioner will determine that. And failure to remove that material will lead to very large fines and potential criminal prosecution for multiple parties involved in that. So again, that's pretty serious. Non-consensual intimate image sharing, so the revenge porn, very serious issue. One of the things that has not really been adequately addressed by previous legislation in this area, as explored by folks like Dr. Fiona Martin, who also contributed to our submission, is that deep fake images, manipulated images, were not either clearly not covered, or it was unclear if they were covered by legislation. And of course, quite a lot of imagery used in these contexts can be manipulated in sometimes very grotesque ways. So it's not just unmanipulated images. The good news is this legislation, this new Act, makes no distinction. It says it's an immaterial, it could be manipulated or not manipulated, as long as it's non-consensual and it's an intimate image. So if it's your face on a deep fake body, it is considered part of this provision. So that's actually, I think, good news, particularly for the victims of that fairly horrific crime. So platforms, hosts, and end users who post that material can be issued takedown notices from the Commissioner within 24 hours. So they have 24 hours to get that offline. There are civil penalties for the end users who post these images of up to $55,000. That's an increase. And again, it works in harmony. There are state-based and territory-based criminal laws that actually do address image-based abuse that are continually iterating. So just because the Commissioner has addressed this and may issue a takedown notice and or a fine or penalty of some kind, the individual who posted that material may also have criminal charges brought under one of these other acts and laws as well. Some other things to note, there's quite an extension of powers under this new Act, which some are very comfortable with, some are less comfortable with, but it is now the law. In particular, the Act grants the e-safety Commissioner the ability to obtain contact information and identifying information from service providers like a social media service or an ISP about individuals who may be using anonymous accounts to breach one of the things that we've been talking about, to post a non-consensual intimate image, to abuse a fellow adult, to bully a child. If they do not provide that information when requested, that can result in fines. So there is a fine for non-compliance of that. They do have to deem that it is necessary and demonstrate it's necessary to their investigation of the issue, and they have responsibilities around that as well. But they do have that new power to actually compel that information. There's also a line in there and the quote is right here, that it grants the eSafety Commissioner the power to do all things necessary or convenient to be done in connection with the performance of the eSafety Commissioner's functions. So it's a very broad term, and it really just is looking to establish that foundation for, giving the eSafety Commissioner bite to back up its buck, giving it the ability to actually take action if they deem action is appropriate. We do know all over the world, including Australia, sometimes very well-intended, noble regulatory efforts can be in reality quite toothless, and people they can't follow through. So and people learn that, and the social norms don't change, and there is still some really abusive and bad stuff that happens. So this is intended to give them the agency to actually go and make a difference and make an impact. So what does that all actually mean in reality for us, for those of us who work on and in online communities? Well, the headline is, if you are already doing the right thing, if you have governance in place, if you are actively moderating and community managing, there's very little that you have to change. So that's good. You're already in a pretty great place. You're already, adopting all of the most successful, effective mitigating strategies for some of these abuses in the form of moderation and community management. But if you don't do any of those things, then you will need to change some things. If you work primarily on social media platforms, so if your communities are there, if you're running and maintaining digital audiences there, the hope is, you might see an improvement in platform compliance with addressing serial trolls and abusers, which in turn would then hopefully impact the overall sort of social health of your environment and your staff. We know that community managers working in social media in particular have, it's a lot of emotional labour and psychic labour. They have incredibly stressful environments, and there are some very serious health and mental health outcomes from that. Community managers around the country have been investing in things like resilience training to support themselves and their teams because of those stresses. It's really significant if you sit there and consume that kind of abusive content all day in and out. So if there is a shift in that, even a small one, I think that's a welcome shift. It also means that your adult users in your environment and your community or social media staff, because they are also adult users of that environment, can report abuse directly to the eSafety Commissioner as well as the platform. And I also think that's largely a welcome change. Again, we know that particularly with platforms of epic scale, like the Facebooks of the world, and they don't, I must say, have the greatest track record in being responsive to these things, and there's an inconsistency of response. Yes, it's important to report so they have visibility of what's happening and give them a chance to do the right thing and address serious issues. But often things aren't addressed, or they aren't addressed in a timely fashion, and that's cold comfort to somebody who's experiencing that abuse or that, that graphic content or one of these other issues we've talked about. So at least now it does give you that additional option, that additional agency of reaching out to the eSafety Commissioner, sharing records, and we'll talk about the importance of that momentarily, and logging a report and hopefully having something addressed. It also means that your users, if they are the abusers or they are the culprits, or the alleged culprits in these cases, they can be reported to the platforms or the Commissioner as well. So those are the primary impacts. We'll talk about some tips for making sure you're ready in a moment. If you work on an owned community, so if you have a forum or an internet that's open to hundreds or thousands of staff, you and your organisation will need to comply with the basic online safety expectations. So too do the social media platforms, but obviously we don't have control over that. You will need to comply, including those reporting mechanisms, processes to respond to takedown requests and complaints, should they be lodged, and requests for that information pertaining to compliance, such as transparency reporting. It also means that your users can report abuse not just to you, but potentially to the eSafety Commissioner. This is an excellent question from Claire that I'm going to take. Reach Out. Yes, I'm familiar with Reach Out. They're awesome. One of our finest communities here in Australia. Reach Out is a youth mental health forum. So there's a lot of triggering discussions, absolutely, that we moderate and ensure safety, but are not sure about the psychological harm to children, Eric. Yeah, it's a really great point. We're not sure either, to be honest, Claire. The children stuff, I mean, I think the Act tries to be very clear that it is targeted bullying. So if you have a user that is bullying another user, I know I'm familiar with the level of robustness of your processes, and I am very confident that that would be safely managed and not escalate. But that is the type of stuff they're talking about, and particularly with kids, exposure to that class 1 and class 2 material, if that makes sense. So, you know, if you happen to have any graphic content that finds its way on there, again, I'm very confident that would be picked up by your existing system. So if you think there's a vulnerability there, I guess that is something to explore. In terms of discussing issues that might result in harm, or even the discussion of harms, this is an area, this is nuance not captured in the Act. So we will have to see how this plays out. Ultimately, you know, for the e-Commissioner to become aware of it and to act on it, somebody has to alert them, somebody has to make a report. So it would take one of your members or somebody, perhaps a guardian of a member, actually lodging a report. My hope is that they would come to you first to have that discussion, or you know, your members will be comfortable reaching out to your team. So I suppose one tip there is to, you know, make it very clear that you prefer that avenue of communication, that you would encourage those discussions to be had with you and the team first, potentially, rather than escalating. And again, like with all these things, if you do receive a removal notice or respond to an issue, as long as you part of what's required there, just as with things like the VOLA ruling, is that you demonstrate how you're solving these problems. So you show a little of your inner workings and the degree to which you moderate intentionally, holistically, responsibly. The Safety Commissioner, I'm betting, would probably say, yeah, you've got the situation well in hand. They may request you do something with that particular bit of content, but then speak to your broader environment, if that makes sense. I hope that's a decent answer. I'm going to get clarification on all of these questions.
Ness?
Yes.
Ness, sorry, can I just put my hand up? So that question, if you're talking about moderating a support conversation in which people are talking through triggering, then the contextual element, which is this is a support community in which we talk about these things, would actually mean that you would pass the reasonable person test.
Yeah.
I mean, for those of you who don't know, the standard definition of a reasonable person under Australian law is, and I kid you not, this is it, the man on the Bondi tram. That's how old it is. Raises all sorts of questions about like internalized and like, you know, racism and all sorts of stuff because that person's white and whatever. But because of the nature of the community there, because the point is to have these discussions with children in an environment which is monitored and has psychological care over the top of it, I wouldn't be worried about this.
Yeah, thanks, Jen. It's a really good point. And I was momentarily forgetting the reasonable person test. You're exactly right. Context does matter, you know, and we know all very much how much it matters. And the good thing is, you know, I see a number of lines in the Act that speak to context. And I also do know some of the team at the Youth Safety Commissioner, and they are, you know, they're smart, compassionate people, and they are working to consider context very carefully. So I'm pretty confident that, you know, things like that would not be a problem for you. I've just got a question from Annabelle. Is it reasonable to expect that service providers will be able to provide sufficient identifying info if required? It's a great question. I can't really tell you if it's reasonable. It is the rule now. I think, look, it depends. I think for probably to some degree, it depends on the nature of the service, obviously. You know, certainly I think some form of contact info. So it's not required that, you know, you hand over, you know, name, birth date, home address, necessarily all of that. You know, a name and an email is I'm betting 9 times out of 10 more than enough. And you can only provide what you have. So I think, you know, if thinking about the nature of the services that you provide or that a service provider does offer, is it appropriate to capture some of that information? And then, you know, how comfortable are you in passing that along if that occurs? Again, I imagine if it's a question of abuse or, you know, breaching one of these standards or you know, criminal codes, you would probably be okay in passing some of those things along. You probably want to not, you know, not endorse that happening on your service, and you probably be, by the time it got to that stage, you may have already, you know, asked that person to leave, you may have already banned them, blocked them, booted them off the service. So I don't see that happening a lot. And my suspicion, but this is just purely my suspicion, is that it, you know, it will be applied in some, particularly in cases of organised abuse, where there are sort of conspiring actors. There are, you know, communities and digital gangs that sort of get quite organised sometimes in terms of the abuse and havoc that they can wreak. And I suspect that there might be some, you know, some involvement in terms of trying to capture everybody within that group, similar to the way that police approach kind of a dragnet. So that's purely my supposition, to be very clear. Question from Michael. I hope that answered your question, Annabelle. Sing out if it did not. Michael, have the large social media platforms made any comments on the legislation? And if a member of the public takes candid footage of my team conducting the normal duties of their job and then posts it, is there any mechanism within the legislation to address this? That's a great question. Not really, no. Depends on what you're doing. It depends on the activities. If you were, if it was an intimate image, yes. If that would really be more of a question of, you know, what are they saying in conjunction with posting that? Are they saying anything that's defamatory? Because, you know, images will identify you, so then that could fall under, you know, could become an issue of defamation, a question of defamation. It might, what's the other thing I was going to say? Sorry, I've lost my train of thought. Various privacy legislation as well. So nothing explicitly in the Act addresses that scenario. No, it doesn't. So it would have to be something in conjunction with that. So as they post that, are they saying abusive things about that team member? Are they, you know, inviting or inciting others to attack them somehow? If some of those things are happening, yes, those other, you know, the adult abuse provisions would sound like they would kick in. In terms of large social media platforms making comments, they have not actually made public statements yet. Most of them did submit to the Act during the submission period, and those are all publicly available. And if you're interested, I encourage you to read them. I've read through several of them. They're very interesting. Some are very reasonable. I read Twitter's top to bottom. That was, I thought, generally a very really good submission that broadly supported the Act and had some points, you know, had some concerns about timeframes and their feasibility of being able to do that, but otherwise was broadly supportive. So I don't know. It remains to be seen. I suspect you'll see a bit more, and it will happen as incidences start to manifest, you know, where reports aren't met, you know, reports aren't complied with, takedowns don't happen or do happen, and we'll see how they respond then. Katie, for own communities, does that apply to systems like Microsoft Teams that are used within an organisation? Technically, yes. Just as the VOLA ruling and defamation applies, anything that is accessible by those multiple users, so really more than 3 users, yes, it does. And obviously, theoretically, that, you know, that content could also be screen grabbed and shared externally, even though that's highly unlikely. So yes, it does. Again, the likelihood of things happening in that type of environment is usually lower. They're usually more high governance environments. So the likelihood of any of this stuff occurring is probably quite low. So I don't think you've got too much to worry about, but theoretically, yes, it does. Oh, thank you, Paul. Paul, our resident ACM lawyer, has clarified what I said. Good, I was right. Section 5 defines a child as an individual who has not yet reached 18 years. So it is under 18. That's what I thought. So, of course, you do have, obviously, a lot of our platforms, you know, have 13 or 14 as that threshold of use. So they are still considered children, even regardless of whether they are legally allowed to use the service in the eyes of the service itself. Natasha, re-adult abuse. Does this apply to social media users who abuse an organisation and its employees generally via their Facebook, Twitter, etc., which is obviously being monitored, responded? That's a really good question. I don't think it does. It's definitely not made clear. And that is the example of the type of harm not captured by this Act. Now, if they are, I think there's an argument, and I would be very interested in a test on this for, you know, we know as community managers, that particularly those manning a social media account, a social media manager of that nature, cops an awful lot of abuse. And if that abuse becomes personal, even if they don't know who you are and don't identify you, I would be interested to see if that could apply. It's not clear. It's not stipulated, but in answer to your question, I will ask them, and I think there should be a case for that. If it meets all other thresholds, so if that serious harm threshold is met, if all of those other criteria are met, I would be interested in why it did not meet that. It might be talking about, if it's directed at the organisation, then probably not. But if it's directed at you as an individual, even if you are unnamed and unknown to the person doing the attacking, then yeah, I would say there could be something there. I hope that answers your question. It's also something we'll see clarification on. A great comment from Paul. One interesting element to the Act is that it creates a buffer between individuals and the courts. This is true. And even those posting abusive, unsafe material in that, like with the Privacy Act, individuals can't take legal action for breaches of the Act themselves. They have to go to the Commissioner, and it's then up to the Commissioner as to whether or not they can exercise their powers or seek court orders. That may be great if the Commission is appropriately resourced, but I fear there will be large bottlenecks. That is a very important point. I also fear there will be large bottlenecks based only on the amount of uninvestigated reports that the Commissioner was not able to attend to, before these provisions were in place. So I do know that the E-Safety Commissioner is hiring a lot of people right now, and that they are working very hard with some of their funding to resource up to deliver this Act. They've been developing it for 6 years. That Julian Grant, the Commissioner, takes it very seriously. She really cares about doing this right. So I know they're intending to, and they're very cognizant of resourcing, but yes, I don't know if they know how much they might be in for. So that's a really great point, Paul. Thank you. Keep asking questions. I'll just share some of the tips that we have for compliance. So the ones I mentioned before, and again, if you are doing these, you're already in a really great position. So consistent, consequential moderation. Consequential meaning, there's accountability. People don't get away with inappropriate, toxic, bad behaviour or bad, inappropriate content. In general, best practice online community governance. So, your guidelines of use, your terms of use, your various policies, some form of risk triage and escalation is essential for all online communities. Exactly how you do that, the exact style of documentation, we have some guidance around that we offer at ACM, but it's ultimately it's up to you, and you want to keep it in harmony with your organisational governance styles and templates. But some way to know if you're being hammered with a lot of things at the same time. What do we deal with first? Who is alerted? What is our, our service level agreement? How quickly do we need to deal with a claim of defamation versus, somebody bullying somebody versus spam, right? You need to have real clarity on that for everybody working in those online community environments. Response guides are also fairly common, and I do advise that, that you consider them. So scripts, not that you would issue them as a script prescriptively. We want to obviously keep all of our online interactions real and human as much as possible, but making, bucketing up the key risks, the key issues, the common things that are going to happen in your community, and having clear guidance around, responses and talking points. A response to, for example, a threat of self-harm should include the following X, Y, Z. All of our mental health online communities in Australia do this exceptionally well. They really set the standard. So, in those response guides, for example, now you can do things like let people know about this process. So if you have a member that is calling out abuse from another member, you could let them know, hey, here's a link to the reporting have you reported to the platform? If you have already, here is a link to the E-Safety Commissioner's form to go and lodge this report. You can let them know about keeping records. As with law enforcement, it is very important to keep records of these things. So if you or your users or your members are experiencing any of these things, keep as many screenshots and records as you can, note things in context. The more, the better. I understand it's not always possible, and even the keeping of those records can compound trauma when abuse is happening. So I'm really mindful of that, as is the Commissioner, but it is important, particularly if you are looking at a pattern of abuse. One thing we did get clarification of in our submission, we queried about the how some might weaponize the reporting process. You know, lots of bad actors just look for new tools to weaponize, and there could be some that will lodge false reports to get people into trouble, use it as another tool to wreak harm, and they may simply keep piling on the abuse, knowing that the reporting is occurring, so they can add to the burden of reporting, which, as I said, has been known and shown to compound that trauma, and it becomes really an extension of the abuse. So we have clarification that, you know, you don't have to lodge a new report every time something happens. So if you have a serial troll or serial harasser, abuser of some kind, and they are coming at you constantly, you don't need to consistently go through the entire process again. Thankfully, you can keep records and add to existing complaints, which is, you know, sounds simple, but is actually a really important point for those that do experience that sort of stuff. If you are an owned community, you will need to add into your existing policies and processes. What do we do if we get a notice from the eSafety Commissioner? It's probably very unlikely, but if we do get a takedown notice or another kind of notice, how do we respond? We need to make sure we're compliant with that 24 hours. Who's going to do that? Who's involved? What do we need? What do we need to have in place? You need to train, obviously, all your staff that are going to need to be involved in that. And if you're building any kind of a social product, I've been talking in recent months to a number of folks building new social platforms in Australia, which is really exciting. They are all going to have to make sure that they are compliant with those new basic online safety expectations. Thankfully, the ones I was talking to all are heading down that track already, but now it's, it will be required. Something I want to call out. So concerns and issues. If your communities, there has been some commentary about the Act that I think is fair in relation to the treatment of graphic material. So obviously there are many abusive and harmful applications of the material covered by the Act, the Class 1 and 2 material and abhorrent violent content. However, there are also safe, legal and healthy applications of things like adult content. So communities, including, for example, sex workers in Australia, have raised concern that their online interactions and their private and semi-public online communities could be negatively affected by this Act. They might be subject to takedown notices. They might have to sort of go underground effectively in order to safely gather and have the discussions they want or need to have. If you host a community or manage or convene in any way, look after a community that might feature adult content or sensitive subject matter, it's worth digging deeper into this, to be really clear about, can your members still have those discussions freely? Can they share that content? And if they may be concerned, they may hear about this in the news, so it's worth having a conversation with them, or at least those community leaders or champions within your environment. So too, something like, a group that's dedicated to discussing and sharing images of graphic police violence, they might also be subject to that. So, again, the Act calls out the importance of balancing free speech. The Act calls out and acknowledges sensitive contexts of this sort of nature that doesn't specify these. So I'm fairly confident these sort of, false positives, if you like, will be minimal, but they may happen. And on the weaponization point, others may choose to target those communities for ideological, moral reasons as an extension of abuse and so on. They may want to shut those conversations down. Or further minimise or marginalise those groups or communities. So they may use the mechanisms of the Act in that way. So we need to see how that plays out, but it is something to be mindful of, particularly if you have those types of communities. Also worth noting, misinformation was totally out of scope for the Act. Obviously, it is a separate issue, but there is a demonstrated connection in the research between things like serious harms, particularly hate speech and harassment, and misinformation, and how it's used by certain groups and individuals to kind of cultivate, misperceptions about a particular group or class of people, how it's used to foster hate and things like that. So just worth calling that out. Katie, I would be interested to see if this changes how platforms like Facebook and Instagram AI and automate responses to consensual images that are revealing. Yes. I.e. Instagram that says now exposed bottoms and images with large quantities of flesh tone are too risque. It's a really good point. Another concern that was raised by some in Australia in the discussion and debate around the Act was that as well. So people that understand the way content moderation works, as most of you in the room do, recognise that to do this, to be compliant, major platforms will likely increase investment in AI and automation, which can be occasionally helpful, but we also know from our own direct research and from a lot of really great research from scholars and industry out there, can really compound harms and really fails to address the nuance and the context in these situations. You know, we still need our community custodians as context coaches. It's really, really important. So it could result in more algorithmic bias. It could result in kind of marginalization we just discussed due to the mechanism that Katie just described, where you have platforms deciding that it's just too risky, they're just not going to bother. So yeah, you know, a burlesque dancer might find themselves shadow banned on Instagram because Instagram's just like, it's just too much. We just don't know. So we'll just take that easy way out, or we'll just, you know, overcorrect the system to deal with this. So again, it's yet to be seen. I also, Katie, will be very interested to see how it all plays out. I suspect, as with all new legislation, there'll be sort of some settling of the dust while we figure all those things out. There might be some minor tweaks and corrections either way, but it will be interesting. You know, broadly, ACM and me personally, you know, we are happy, pleased that there is some recognition that a lot of adult abuse occurs online and that there are some now real tangible punitive measures around that. I think that's an incredibly important step, our world first step. Again, it's not going to solve the problem. There are some really systemic issues behind all of that, but it is some comfort, I know, for those that face that abuse, including community managers, on a really consistent basis. So that's it. That's our high level summary. So we've got some resources that I'll send out with these slides. So Digital Rights Watch also has a really good breakdown of the bill, so the Act and all of its contents. We've got a link to our submission if you'd like to read that. You can also, on the same site, just take off everything before the submission slash, and you can see all the other submissions, including any major platform submissions, and the actual bill itself, which is available in PDF and Word for everybody to read. I found it refreshingly simple reading compared to quite a lot of legislation. It's actually really easy to understand, I think, so, and has some decent definitions in there to help clear things up. So any other questions or anything anyone wants to chat about before we finish up? If anyone needs help with their governance, please reach out to ACM. You know, we do help folks with that. Our pro members are able to do that whenever they like, and we offer both kind of training, consulting services, and we'll happily just answer a few questions if that's all you need, so you can kind of get up to speed, and we can audit what you've got as well. So, you know, just sort of double check that everything's in order and sort of aligned with you know, best practices. How's everyone feeling? Regulated? Yeah. How do people feel about the Act generally? Are you in favour, you know, half full, half empty, bit of both? Personally, I'm sort of maybe half full, but, you know, with some questions and concerns, I think, as with all this sort of stuff. My concern about historical legislation in many countries, but definitely in Australia, is that a lot of it, you know, we try to regulate the wrong thing or the thing that doesn't really need the attention, or over-regulate a little niche area, leaving gaping holes with some areas that really could do with some judicial support or regulatory support. So I'm, you know, really pleased that this Act at least, you know, really does, I think, address some of those blind spots that have been there previously. Cool. All right. Well, if anyone's got any other questions, don't hesitate to send them through. We're going to save all the questions you asked, and we're going to field them to the E-Safety Commissioner, who will give you answers. Some of those answers might be they don't know exactly yet either, but we will come back with a response for you. And if a question occurs to you after the fact, totally fine. Just send that one on through as well, and we will gather them all up. Amanda, from Natasha. Can I just clarify, if we have managed a Facebook or Instagram page, does the Act apply to the organisation? No, Natasha, it would only apply to Facebook, because that's the platform that you're on, and it would apply to your end users, which would include you or any community team members that work on the page. So the end users and the social media service, which in this case is Facebook. If you had your own forum or your own app, you know, say you were using you know, say you built your own app, there are a number of private online communities in Australia that do that. That would apply to them as the service provider, as the organisation as well. Cassandra asks, Danielle, encouraged that the changes have been made, but waiting for it to be abused by people, it's supposed to be regulated. Yeah, I think you're right, Danielle. I do think there's a risk of weaponization, for sure. There always is, and I think it's, you know, sadly par for the course with any rules. Someone's going to abuse them, but I do think it's the punitive measures are at least there's some additional deterrent other than the hard work that community managers put in. Cassandra asks, it would be great to hear how it applies to schools, TAFEs, unis and well. Yeah, that's a really great question, Cassandra. Broadly speaking, I mean, again, it's if you are hosting the platform, if you're the host or the builder of the software, you do need to be compliant with those basic online safety expectations as laid out. And if you're using an external platform, the platform holder does, but you should be, as I said, ensuring that you have, you know, standard governance stuff in place. So, you know, reporting mechanisms. If you've got all the basics in place, there's not a lot of extra stuff you need to do. And if you're doing that regular, consistent community management and moderation, you're in a really good spot. It just means that your users actually have some additional avenues available to them, rather than just reporting to the platforms, which we know can sometimes feel like a little bit of a lost cause. Cool. Thank you, Jane. That's great. Awesome. Thank you, everyone, so much for your attention. It's a busy time. I know lots of the country's in lockdown as well. So my thoughts and love and affection to all of you there. I'm in Victoria. We've been there. We're not there right now. We may be there again, but I feel your pain. We will send these all out to you, gather those questions up. If you have extra questions, as I said, just send them through. Thanks for everything. Thanks for being here.
Thanks, Ness.
Yeah.